Welcome back to Law and Crime Live. I'm your host this afternoon, Caroline Polisi, and court is on lunch recess in the case of William Knight out of Akron, Ohio. Now, William Knight, age 64, thought that Keith Johnson, age 24, was the thief of a dirt bike that he and his family owned. He's not denying that he actually shot at Johnson, but he claims it was self-defense. The question is, was this involuntary or was it an intended homicide? I'm joined in set today with Julie Rendelman, Law and Crime trial analyst. Julie, thanks for being with us.
Thank you for having me.
And also via Skype, Joseph Scott Morgan. He's a forensic death investigator. Joseph, thank you for being with us.
Thanks for having me, Carolyn.
So, guys, we just heard the prosecution rest its case earlier this morning, and the defense actually started putting on its case. We heard this morning from Curtis Gill, the son-in-law of the defendant in this case, and we just heard from Michelle Gill, the daughter, who initially made that 911 call. I have to say, I don't think that these were good defense witnesses. Julie, what's your initial take?
I might be in a little disagreement. You know, look, if we follow what we had talked about earlier, which was the issue of the law of self-defense in Ohio, then I agree with you that there's some issues, and those issues would exist whether Ms. Gill testifies or not, or whether Michelle testifies or not. But I do think that they at least start to establish that, you know, there is some level of fear and some concern as to, in terms of the bike heading towards them, that the defendant may in some way interpret as being some type of danger to his family. I'm not saying it makes out a pure self-defense, because I don't think it does.
Right.
But I don't think that there'd be any testimony in this case that will make out the pure self-defense that the defense is looking for. And in a way, I don't know that I think the defense probably recognizes that they're looking at trying to get off of the intentional. I don't think they're looking, as far as I'm concerned, I don't think they're expecting a pure acquittal.
Well, okay, so we know that initially the prosecutors in this case did not charge the highest crime that they now came back with and charged with, which is this intentional murder. Can you describe a little bit about the law of self-defense? What is the difference? I know you practice mainly in New York, but what's the standard in Ohio for a defendant to claim self-defense?
So I think that the standard is different there. I mean, but just so we're clear, every state, and Joseph, you can join in whenever you disagree or agree with me, but I think every state is different as to the rules of self-defense. In specifically to Ohio, the rule requires that the individual have an actual danger, like that he perceives an actual danger for which deadly physical force is the only option. And one of the biggest things I think that we talked about before is that there is a duty to retreat. And so that, to me, is the big concern here. However, I have to add one thing, is the curious part about it is when someone is acting in self-defense, they're not always acting for self-defense of themselves. They're acting for self-defense of themselves and others. And in this case, he's arguing that the self-defense is of his daughter, potentially his son-in-law. And so when you start to talk about the duty to retreat, whose duty is it to retreat? Is his duty to retreat, to walk away from what he's watching as a perceived threat to his daughter and his son-in-law, or is his duty to retreat separate and apart from that? And that's where I think that maybe self-defense can be a little confusing in Ohio, specifically to the jurors in this case. Interesting.
Now, Joseph, I want to talk a little bit about, obviously, your area of expertise is the forensics in this case. So we know that the victim in this case died instantly on the spot. He was hit in the head. We also know that there was an entrance wound but no exit wound from the medical examiner's testimony. Can you speak a little bit to how that forensic evidence is going to play into a self-defense defense of this defendant? Sorry, defense defendant.
I like
that's
that.
Okay. Yeah, the perception, you know, again, kind of going back to what Julie was saying very, very briefly here, the idea here is perception meets reality, doesn't it? And whatever their perception of what's going on at that moment in time. The gunshot wound that the victim sustained was in the temple, and there is no exit. There is also an indeterminate range of fire at this point in time. So this means that the muzzle of the weapon would have had to have been out further than probably about 18 inches away from the body. Keep in mind that when a a blast takes place out of the end of the muzzle of a gun, it's not just the bullet that's coming out of the gun. It's all of the debris that's kicked up from the ammo that's being fired, the unburnt powder, the smoke, and even if you've ever seen images of a weapon being fired at night, there's actually a little heat plume that comes out of the end of the muzzle. And this relates to scoring on the edge of the weapon, on the margins of the injury. So there's no evidence of that, apparently. And it's an interesting position because it would have been to the side of the head if it was a temple shot, and there is no exit. He would have to have been out of that range. So was he actually backing up, retreating when he fired this weapon, or was he in a static position? And in this dynamic, if the victim is on the motorbike and he perceives him to be advancing, that is the shooter perceives the victim to be advancing on his position, and he's trying to retreat. Well, it's really hard to retreat from somebody that's on a motorized vehicle. And let's be real firm about this. A motorized vehicle can be used as a weapon. And if that is his perception, I'm not saying it's right or wrong, but the defense can certainly throw that up and say, hey, this guy was thinking that, his family members, himself, they were going to be run over by this motorcycle.
Absolutely.
And so he had to end that engagement at that moment in time.
Yeah, Julie, look, I mean, we know that the defendant in this case had a concealed carry license. I mean, he came to the scene with a gun.
Right.
Talk a little bit about, these kind of atypical weapons being used in the case of being fearful of your life. Does that really fly? Are they going to say that a dirt bike is a deadly weapon?
Well, dirt bike, I think Joseph is exactly right. A dirt bike, like anything, can be a deadly weapon depending on the scenario that we're talking about. And I do certainly think that a gunshot wound to the front of the victim is more helpful to the defense than it is hurtful, because obviously if we had a situation where he was shot to the back or shot multiple times to the back, it would be much worse for the defense's position. So, I think that in a way it bodes well. I think there's a perception as to who kind of created this situation. And,
right.
And when we talk about the guns, and I'm not going down a political road at all, but we have to be cognizant of the fact that this is an individual that purchased a gun license a short period of time before, had not, arguably, and I haven't heard differently, this was not something he normally possessed. It's new to him. And so when you start to bring a gun to an argument that is a pretty low-level argument, this is a fight over a $3,000 to $5,000 dirt bike,
right.
Potentially something's going to go wrong. And so it starts to make you have inevitably some conversation about why a gun should be allowed to be in that situation in the first place. I have to say it. That's
I agree. Bombshell to drop, Julie, in the middle, which is why
Sorry.
we're going to go. No, it's okay.
Sorry.
Which is why we're going to go to a clip now. I want to just let viewers see a little bit of the cross-examination of Curtis Gill. He's the son-in-law of the defendant in this case, and it's very interesting. Julie, we can hash it out afterwards because I thought he was a terrible defense witness, but take a listen and let's see.
We had decided, I'd left, and I'd asked Bill if he would be able to haul it before I left.
Why, if you had a Ford 250 pickup truck, did you need Bill to come haul the bike?
My truck was loaded with tools.
Okay. The entire back?
I believe so at the time, yes.
Okay. And you have a cap on it?
I have a tonneau cover.
What kind of cover?
Tonneau cover.
Okay. And when you say that, what kind of cover is that? Describe it for us.
It's like a flat, not leather, but just flat cover that goes over the bed of the truck.
And it's not very high, right? Like
it sits flush with the bed of the truck.
Okay. So there's no more height to it than the height of the actual truck.
Correct.
Were you expecting your father-in-law to be at your house when you initially found the bike?
No.
And you were already in the process of trying to get the bike back when your father-in-law showed up. Is that fair?
Yes.
How long was he there while you were there? How long was he at your house while you were at the house? If at all?
Maybe 15 minutes.
Okay. And during that time, how far along in the process were you of setting up this meeting?
over 2 hours into it.
If he didn't come, what were you going to do about getting the bike if your truck had full of tools?
I would have hooked up my trailer and took it.
Okay. And so at some point you decided he's here, and then you're getting ready to leave, you're walking out the door, and then you say to him, hey, by the way, I'm going to get this bike right now from this guy who's stolen it. And at that point is the first time you ask him to come with you.
Yep.
Okay? If he had said no, you would have been on your way to this meeting to get your bike with a full truck, correct?
I would have.
All right, that was testimony from Curtis Gill, the son-in-law to William Knight, earlier today on the stand. I'm joined in studio with Julie Rendelman, Law and Crime Trial Analyst, and Joseph Scott Morgan, Forensic Death Analyst. Thank you both for being with us today. Joseph, I want to talk with you a little bit about, so we have this issue of, by all accounts, everybody pulled up to this transaction thinking it was going to sort of not be that big of a deal. Everybody was calm, cool, and collected. And over the course of really just several minutes, things really escalated out of control. And I think we've heard from several different witnesses now that say that the point at which the inflection point, if you will, in this transaction was when Curtis Gill took out or mentioned the fact that he had title to this dirt bike. Remember, Curtis Gill was under the impression that the victim in this case was the one that originally stole the dirt bike. It was a mistaken assumption. It turns out that he realized afterwards, but that's the idea. They were sort of conducting a bit of an undercover sting operation, if you will, trying to come up on whom they thought was the person who stole the dirt bike, and then show him, look, hey, I've got this title. Can you talk a little bit about sort of the escalation and the escalating nature of where the law comes into play in terms of force needed in terms of self-defense in this type of situation?
Yeah, and I think that our listeners at home probably have this perception of escalation as it applies to the police. And the police world law enforcement world is completely different than the civilian world. In the police academy, police officers are taught how to de-escalate an event. If they're just conducting an investigation just to inquire, the police very well might ask a few questions, take a look around, and then leave. But for a civilian that enters into this situation, it begins to escalate and finally bubbles over into an argument. Well, at that point in time, the individuals have two choices that initiate this. Either they can retreat or they can turn to violence. And in this particular case, they turn to violence. With the police, they have a higher standard that they have to meet than the civilian population. Police just don't automatically draw their weapons. This is something that they try to talk people down.
Yeah.
They try to talk people down, and then there is a progression that they have to go through before they ever get to the level of lethal. This thing went from 0 to 90 in just a matter of seconds. And when that happens, it turns into total and utter chaos at that point, and then ends up tragic. And that's why a lot of this is perception as opposed to reality. And you've got a lot of anger that's in here. You got a lot of emotion as well. There should be. We've got a young man that is deceased. So it's really kind of hard to vet this. There's no true investigation that's going on the part of the civilians, as you put it. They're trying to scope the situation out. It doesn't work like that in the police world.
Yeah, it's interesting. Julie, we were just listening to that clip from Curtis Gill, and you and I were talking a little bit off camera. I said, it felt like Curtis really wasn't all that scared for his life, and I think you made a pretty apt a comment to that. Yeah. You're changing my mind slowly but surely, because I thought, well, he didn't seem like he was scared.
Right. I think what you said is, he arguably had said at some point, or intimated to the fact that the deceased should be almost more scared of him.
Exactly.
And so my argument is, well, he's not the defendant on trial. And quite honestly, we start to go, well, why isn't he? I mean, I don't know that there'd be any criminal aspect to it, but in a sense, he's quite responsible in many ways for kind of the transaction that occurred. But the fact that he's not necessarily scared of what's transpiring doesn't mean that the defendant, in his perception, is not in a very different situation. Remember, I'm not taking sides, I'm not taking position, but remember, he's a 64-year-old man who is there thinking in his mind, if you accept it to be true, that his daughter, who he has always been known to protect, is somehow in danger. And so that is the perception potentially that he has. That's not the same perception that Mr. Gill has. Now, that could go back and forth with the jury, because the jury could say, well, if one guy didn't find it reasonable, then why would this guy find it reasonable? But I'm not sure that that's necessarily the standard they're going to be looking at.
And does the law take into account, when we heard from the psychologist yesterday, remember there was one of these defense witnesses that had to go out of order. So we heard a little bit earlier about just what you said about the fact that this defendant had sort of, a lot of anxiety, was, led a very sheltered life, was very scared of things. How does that play into sort of the reasonable person standard? Does the jury get to include all those life factors when it's thinking about this defendant?
I'm not sure exactly how reasonableness plays into the Ohio law, and I'm going to be honest, I'm not sure that specific aspect of it. I will say, though, regardless of what the law is, remember now the jury's hearing about this individual and hearing things that make him human.
Right.
And so I was surprised, quite frankly, at some of the things the psychologist was allowed to testify to. I thought it was a bit. It was almost a substitution for
trauma
him testifying.
in the childhood. I mean, how is that relevant?
Even her articulating potentially what it was in his mind at the time. We're trying to intimate exactly what was in his mind at the time. He should be testifying in regard to what was in his mind at the time that happened.
Right.
But she did, I think, testify very well, and she got into, as far as I'm concerned, into the jury's mind that there's a sympathetic character behind that gun. And so, as horrible a crime as it is, which we all agree on, I believe. It does humanize the defendant, and I think plays well for the jury in terms of intimating that potentially he believed that there was fear for his daughter.
I agree. I mean, my heart went out to him, even though I was watching the psychologist testify. It really did humanize the defendant.
Which means she did a very good job.
She was a very good witness for the defense. I want to show our jurors our viewers just a little bit more of the cross of Curtis Gill. He's the son-in-law of William Knight. Take a listen.
He wasn't trying to hit you. He was trying to get away from you. Yes?
Sure, yes.
And when he started the bike up, started to throttle it, if you didn't jump in front of him, you would have not been injured. Is that fair?
At that point, I was in front of him as soon as he started it.
Well, the injury to your hand, the injury to your shin happened as he went by you, and the peg scraped your leg.
Yes, at that time, yes.
Those injuries we see in those pictures are all from you trying to prevent him from leaving. Yes?
Yes.
Is it fair to say that you did not have any reason to believe at that point in time that you were in danger of losing your life or being seriously harmed?
When he went past me, no.
As you were holding him, the only reason there would be any danger to you would be because of your actions, correct?
Most likely.
Welcome back to Law and Crime Live. The court is on lunch break in Akron, Ohio, in the case of William Knight. And we were hearing just then from earlier testimony earlier in the day of the son-in-law of William Knight here, Curtis Gill. I'm joined in studio with Julie Rendelman, Law and Crime trial analyst, and on Skype with Joseph Scott Morgan, forensic death analyst. You guys, we've talked a lot about the William Knight case. I want to shift gears a little bit and let our viewers know that we are coming back next week here covering gavel to gavel the Tex McIver case, which, of course, is a very high-profile case. McIver's on trial for murdering his wife, Diane. She was supposedly the breadwinner in this marriage. They were, by all accounts, very much in love, but underneath the surface, there apparently was some financial difficulties. The question was this an accident, as McIver and his team would have us believe, or was this cold-blooded murder? And both of you, I want to talk a little bit about how we ended up the week last week. They've been on break this week for spring break. Again, we're starting again on Monday. But the prosecution wheeled in these 44 weapons at the end of the day or the week last week, just to show the jury exactly what kind of a guy Tex McIver was. He had said, of course, that he was not a gun guy, and then the prosecutors wheeled these in. It was quite a dramatic and shocking moment, I think. Julie, how effective is that? You're a former prosecutor. How effective are these sort of demonstrative aids when it comes to trials of this nature?
You know, I keep shaking my head every time we talk about certain things that go on in the Tex McIver case, because there's the difference between effective and prejudicial and offensive. And so I wrote about this last week because I said, how desperate is the prosecutor to win their case? And are they willing to win their case at all costs?
Oh.
And when we start to look at what's being brought before the jury, we start to wonder, do they not think they have a good enough case that they have to, as far as I'm concerned, prejudice the jury with showing them all these weapons? Because for the life of me, I don't know how they are in any way relevant to this case.
Okay, but isn't the point, okay, it's not relevant in and of itself, right? Isn't the point that he stated he wasn't a gun guy, so they're just trying to sort of get at his credibility?
Well, first of all, remember, a judge has to make a decision and weigh the probative value with the prejudice. And so there is a way to balance that in front of the jury. And by presenting all of these guns before the jury, there is no way, shape, or form that the judge is balancing the prejudice with the probative. And so there is a way to deal with him having made that statement that may allow the jury to question his credibility. But I think this goes far beyond the pale of what's necessary in terms of a case that has absolutely nothing to do with the amount of guns that he has in his home.
Wow, Julie, I love it when a former prosecutor can see the defense's side. What a breath of fresh air.
Well, now I'm going to get yelled at because I'm sitting the wrong side of things.
No, that's great. That's great.
I've had a very strong view about Tex McIver's case, and I've had a very strong view of the desperation that I view from the prosecution, from what I view as the prosecution. Joe, maybe you feel differently.
Well, wait, I have a question. I have a question for Joseph, and I agree with you. The kind of the reverberations we've been hearing from guest after guest is the prosecution is just sort of throwing everything that they can at the wall to see what sticks. And how many more nurses are we going to hear from? You know, how many witnesses did they put on that stand? It was a lot. But Joseph, this is what I want to ask you. In the same vein as this sort of demonstrative, dramatic effort. We've now heard that the prosecution would like the jury to actually handle the weapon that was used in this case. And I think we actually have a photograph of the weapon, and it'll come up on your screen. There it is. Can you talk to us a little bit about how this is going to exactly happen?
Yeah, and I'm not necessarily surprised. It would be interesting to be a voyeur in the courtroom to see what the reaction will be when they handle this weapon. This weapon, as you remember the last time I was on with you guys, I had one that was very similar to this one that we demonstrated here at the Center for Applied Forensics at Jacksonville State. This is referred to as an airweight. There used to be a whole line of Smith & Wesson weapons that were called Ladysmiths. That are very, very light, and I think that the jury will be surprised at how light this weapon actually is. And they're going to have this, I'm sure that like most people, they're going to think that it would have been more robust in its weight and its feel than it actually is. And so I'll be interested to see if prosecution, in allowing them to handle this weapon, how far they're going to let them go in handling this weapon. If they're going to let them pull the trigger, if they're going to let them actuate the hammer on the weapon. We go back to that kind of moment in time when the ballistics expert actually let slip that hammer and it actuated in court. And I think that we were all kind of surprised by that. So this makes this is a very tactile event. And it's going to kind of bring it home for the jury. And hey, listen, Julie, I'm not going to argue with you on this point. As a matter of fact, I stated kind of clearly the other day relative to the trajectory of this round and the attitude that even the prosecution was putting forth in. He was in his position that they're demonstrating in court. He's got this weapon resting on his thigh. At a peculiar angle, sitting on its side, and it's traversing from the area of his right knee back across her core after it enters this intermediate target, the back of the seat, and then then winds up lodging in the dash area of the vehicle. Yeah, it didn't. For me, just looking at this thing from a forensic standpoint, it didn't seem very purposed, if you will, for someone that was out with a specific intent to shoot someone. I'm not saying that he didn't have that intent. I'm just saying that there's another scenario, I would think, that would be in place here if he were so engaged in wanting to take her life. It was a 1 in a million shot almost that struck her and led to her death.
And I've been saying this, and I couldn't agree with you more. And I said the worst case scenario for him would be that he hits her and injures her in such a way that he has to now spend the rest of the money they have on helping her for rehabilitation, which is arguably what would have happened in this case.
Yeah,
but for the luck or the lack of luck, and then she passed away. So I have so much problem with the intent in this case.
The odds that could have happened it was very likely, considering where this round struck, because it didn't. As I've said, it's inferior. The track of this wound is inferior to her what we refer to as her vitals, like her heart and her lungs. We're talking about an area, that's below the level of the diaphragm and traverses in a kind of oblique way across her body in a very odd trajectory. You couple that with the idea that he is a gun guy, you would think that he would know where to place a lethal shot. And if he were a gun guy with that specific intent, he would know what areas of the body have the most lethality or potential for lethality.
So true. So you guys, what I find interesting too, in both of these cases, the William Knight case and the Tex McIver case, we have a case in which the prosecutors didn't initially charge what they ended up charging. And I want to ask Julie a little bit about, that's pretty atypical, right? For prosecutors to sort of come back after, in each case it was different, but it was an extended period of time to re-up and double down on these charges. First thinking it was involuntary, and then coming back with these murder charges.
I think sometimes, there's several reasons why it happens. Sometimes there's a pure reason, which is that there's additional evidence that they find that establishes that they didn't charge enough, and so that they're going to go back in and charge more, or at least see what the grand jury decides. There's also the other part, which is probably the more cynical part, which is sometimes there's a political backlash from the community as to how they charged initially. And so when that happens, sometimes they do that of which they wouldn't normally do for another case. And so they go back in for, I hate to say the wrong reasons, but potentially the wrong reasons. I think we can distinguish the two because I think that there's an argument to be made that Tex McIver, they went in for the wrong reasons. And I think with this case that we have before us, they may have gone in for the right reasons. I think that there was real questions about whether or not he acted in self-defense. And I think that this is definitely the case where a jury should be making the decision as to whether or not he acted intentionally or not. Whereas I think I can delineate the McIver case because I can't believe we're sitting here on this trial.
Well, so deconstruct that a little bit for me. What do you think the wrong reasons were that the prosecution re-upped these charges?
On McIver? I think there was a lot of pressure. I think there was questions being made about, well, is it because Tex McIver has a lot of power in the community that they're not doing it that way? And they almost went after him more to prove that he didn't have the power, quote unquote, that they had. Again, when we start to look at the various pieces, as far as I'm concerned, when we start to look at the various pieces of evidence that the prosecution has put forward on the McIver case to use as proof that he has committed this crime, I've had trouble with almost every single piece from beginning to the end. Let's not forget, they intimated that he at some point didn't even get out of the car to help her, and there was a video that showed him rushing to help her. So at every step of the way, I think that they are trying their best to go after someone that they don't have a case with. And so I admit that I distinguish the two, and I think that there may have been questions as to why they went forward on that one.
They put that nurse up on the stand, remember, testifying that she had heard Tex McIver say something about coming out of the bathroom. So they were kind of like trying to throw in this alternate theory there that maybe they weren't in the car. I thought that was really mind-blowing and just very, very confusing for any juror.
Well, I think it was meant to be confusing.
That's their number one sort of weapon.
Right, and I think it's the same thing we talked about when you joked about how many nurses. mean, I don't understand what they were getting at with the various witnesses. They could have, first of all, done, we started with the indication of the witnesses in regards to his financial situation, and that fell really flat as far as I'm concerned. And so we haven't gone much further up since then. And we always said, let's see if there's more. I've yet to see that there's more, and this has been going on for weeks and weeks. And so I question it.
I know, they came out really strong in this case, really strong with their opening statement. I thought, wow, this is going to be, a trial for everybody to watch. And it just kind of they never really put forth, they never really got it over the finish line there. But yes?
No, I agree with you. And I think that makes you question why they did it.
100%. I think in both of these cases, we're seeing it's a real coup for the defense to be able to argue that initially the prosecutors didn't see this as a voluntary act or an intentional act, and I think that is really going to play into both of these defenses. We'll see how it all plays out. Again, next week we are covering the Tex McIver case here on Law and Crime Live. We are also covering a new type of trial for Law and Crime, a civil case, and we're calling it the David Copperfield case. It's the case of Gavin Cox. He's suing David Copperfield and several other entities, and we may get to see some of David Copperfield's magic tricks as part of this case. I, for one, really want him to appear out of nowhere on the witness stand. I think that would be really cool. But take a listen and see what this case is all about.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
All right. Is David Copperfield going to reveal some of his secrets? We will be covering that case next week on Law and Crime Live. We're also covering, of course, the Tex McIver case. But today, we are covering the case of William Knight out of Akron, Ohio. Court is on lunch recess. I want to show for you a little bit more of Curtis Gill's testimony. He is the son-in-law for the defendant in this case. Take a listen. Welcome back to Law and Crime Live. We are live back in the courtroom of the William Knight case out of Akron, Ohio. I want to thank Julie Rendelman, Law and Crime trial analyst, and Joseph Scott Morgan, forensic death analyst, for being with us here today. Guys, always appreciate your insights into these trials. Please come back and join us. We're going to get you live back to that courtroom. The defendant is on the stand, I'm being told, so let's take a listen.